Well, hello, everybody, and welcome to the How's Percival podcast employment episode. My name's Nick Benton. I'm a partner in the Leicester team at How's Percival. I'm joined today by Hannah Ball, a fellow partner also in the employment team in Leicester. And today's topic, we're going to be discussing the rise of AI, particularly in the context of employee grievances. So let me set the scene for you. You have been dealing with the rumblings of an employee for some time. To date, it's been reasonably cordial. You've been constructive and you feel like you're getting to a good place with the employee and moving past. You come into work on a Monday morning, open up your emails, and there it is, a 50-page grievance from the employee. It's like they're using language that you've not really seen before. It's threatening. It's making repeated demands. It's referencing obscure legislation that you've never seen before, and it's got case law authority backing it up. This is an increasing problem, an increasing issue we are seeing employers have to face. The rise of AI, and in particular large language models, are allowing employees to articulate grievances like they have never done before. And that's causing a lot of problems for employers. It's causing a lot of practical problems in terms of how best to deal with these grievances, bearing in mind what the intention and the purpose of the grievance process is. But it's also potentially exposing employers to additional risks they've not really considered. And it's also knocking employers' confidence in dealing with these grievances, having not seen the references to legislation and case law in grievances before now. So in today's episode, Hannah and I are going to try and look at this in a bit more detail. And we're going to try and look at really tips for how to best spot the use of AI in employee grievances. What or why an AI grievance might be problematic for employers and sort of the issues really to consider in connection with that. And then we'll look at how best to deal with them, what issues to consider when dealing with these AI grievances to address some of these risks or considerations we've highlighted. So, Hannah,
morning, Nick.
From your perspective, what do you think are the signs that a grievance has been created by AI? What should employers be sort of looking out for?
Yeah, often, as you say, unfortunately, it's an email or a letter that makes their heart sink, I think. I mean, some of the most obvious signs you'll often see is, first of all, it probably won't match what the employee would usually send you. Often it might be kind of unfamiliar language or tone, or often we see unusual or odd punctuation in there as well, don't we? So that's one of the warning signs to look out for. It might also, as you said already, Nick, be very long and very complicated. And that, coupled with the unusual formal language, can actually be quite intimidating, I think, for a manager or an HR professional to receive, especially if it does run to about 45 pages, as you said. The other thing that we are really commonly seeing, which I know you talked about a moment ago, is this use of case law and legislation in the grievance. So, historically, I'd say that was relatively unusual to see that in a grievance. Whereas now we're finding where people are using AI to help them draft a grievance, it can be littered with references to cases or relevant legislation. However, whilst AI kind of produces that for the employee with lots of legal references that look, again, really kind of quite intimidating, don't they? Often AI can actually get that wrong. So it might be that they've done it completely wrong. So sometimes AI will hallucinate and it will be a completely fake case or law. Or more commonly, it might be a real case or a real piece of legislation, but that it's misquoted or it's old or it's not, not law anymore, not good law at least. So I think those types of things are some of the key factors that I'd be looking out for as an employer to raise that big old red flag of, I think AI might have assisted or even completely drafted this grievance.
Yeah, I think I absolutely agree. And I think I think that from our experience as well, because we have, as I say, been dealing with these ever increasingly, they tend to follow a predictable format. There's normally bullet points. There's normally horizontal lines. There's normally emboldened sections where emphasis is added. I think more broadly as well, in terms of the type of grievances, is that, and I think this probably speaks to some of the bigger issues which employers are facing, is that they are particularly adversarial. Now, by that, what I mean is they are not really looking for a conciliation or looking to resolve problems necessarily, but they are trying to articulate the employee's grievances in the strongest possible way, which is most often at the expense of that trying to resolve the grievance.
Absolutely. And I think that's why sometimes they're often such a shock for the employer as well. Because as you say, they knew that something was perhaps a little bit amiss and there was perhaps some minor concerns. But to go from that to then receiving a 45-page, very hostile grievance is not what employers want to be receiving. And it really doesn't help resolve any workplace issues, does it?
Exactly. And really, so what, if an employer has received one of these grievances, they're pretty confident that it's been generated with the use of AI. Why do you think that's such a problem for employers? What some of the issues they need to be considering?
Yeah, I think some of the main problems for employers are one, if you just dived straight into investigating all of that grievance, particularly if you're talking about, let's say, a 30, 45-page document, that is going to be just so time consuming, isn't it? And such a distraction. And it's not going to be a good use of the employer's time. And it's really probably not going to help the employee either, mostly because actually AI often distracts away from what the employee is in fact really complaining about. Because as we've talked about before, they're looking at potential claims, they're often looking at incorrect law. So it is actually distracting away from what the employee is really complaining about in any event. So the employer is then going to go off and potentially investigate completely irrelevant complaints, which are going to take a huge amount of time. And I just think that that cannot be the right approach for either the employer or the employee. The other thing that AI often does is it tells people what it thinks they want to hear, essentially. So I think sometimes what that can do is it can really boost the employee's confidence and give them a bit of a false sense of security about their prospects of success with a claim. And so where they might have thought, oh, okay, I think I've got a bit of a minor complaint that I want some help with, by the time they've then run that through AI, they feel like they've got £1 million claim that they're going to succeed with. And I think I mean, I'm being a bit flippant there, but I think, unfortunately, that is what AI is often doing, which can actually mean then reaching a resolution is a lot more difficult. So employers facing, this really complicated, long grievance that actually doesn't really bear much resemblance to what the employee is even complaining about. And I think that, coupled with the fact that the employer is probably quite intimidated by it and also probably doesn't understand the case law and the legislation either, which is right because they're not an employment lawyer or a judge, are they?
No,
I think that can be a real problem if it's not dealt with appropriately. It can lead to a real spiral.
and certainly from my experience, that is the risk. It just it sort of entrenches
Mm.
people into. And I said at the top of the show that I we've seen the parties to these grievances are moving away from what the real sort of central purpose of the grievance process is to try and resolve these matters informally, or at least without recourse to the employment tribunal. And I think you spoke to it earlier, but the sort of real temptation of employers is to look at a 50-page grievance and think they have got to respond to each and every point. And that just sort of exacerbates the problem, doesn't it? So what should employers really sort of bear in mind? Is it right? Should we take it back to basics when we're dealing with with an AI grievance? What should be the sort of first step, do you think, Hannah?
Yeah, I think it is useful to actually go back to basics for a moment and just think, what really is a grievance process trying to achieve for both the employer and the employee? Because it's not meant to be a legal or a court process, is it? That's not the purpose of it. It's designed for employees to be able to raise concerns and complaints about the workplace that are factual concerns or complaints. And then the aim is for those to be resolved once they're investigated. And certainly employers will not, in my mind, be criticised if you did get to tribunal for not, understanding each nuance of the law and trying to apply that in a grievance process, because that's not what they're there for. And I think it's really critical that employers stay mindful of that and not to get intimidated or overwhelmed, because the ACAS code is there as well that helps us investigate grievances. And that clearly states you have to conduct a reasonable process. And in my mind, going through every point of a, 50, 60 page grievance that's, really difficult to decipher and is just littered with case law, I'd be very shocked if a tribunal was to say that it would be, unreasonable to take some form of management of that process and to engage with the employee before you just proceed to, investigate all of that.
I think that's a really important point you make. Tribunals are quite practical in how they approach these matters. They are, I think, unlike many other sort of courts, they operate in the real world. They will be an acceptance of the fact that employers, even those with access to certain resources or legal experts themselves, they will recognise that the managers dealing with these grievances are not legally trained. And as you say, really, the grievances, because it's about determination of fact, not necessarily the specific nuances of case law decisions, which are, let's not forget, they're based on the hearing of the evidence and the application of sort of legal precedent. I agree. I cannot see a tribunal criticising the employer for not making a determination on those case law points. But it's equally right, isn't it, that even if you're faced with the type of grievance, because let's be realistic, I think and we're going to see this now going forward. You can't just ignore a grievance that is produced by AI on the basis that it's not actually the employee's own work.
Yeah, unfortunately, as much as employers might love us to say, yes, absolutely, you can just ignore it, that's not going to be the right course of action, in my opinion. I think, yes, as we've already identified, employers do have to investigate grievances and they have to comply with the ACAS code and carry out a fair procedure. And employees have a right to raise a grievance. So I wouldn't be just immediately dismissing it. No, even if you did suspect it had been entirely drafted by AI.
Yeah, and I think equally with that, it's I think it's as much as you can't ignore them, I think it's going to be really difficult for us to have an outright ban on the use of AI. I just don't think that's going to be possible to police that.
No, I agree. I think AI it's not going away, is it? And it's readily available for everybody to use. I just think, trying to ban that completely is going to be really difficult. And as you say, how are you checking? Because any AI grievance will probably vary quite wildly, I'd say. There'll be some that might look a little bit like what an employee has drafted themselves, and there'll be some that are, complete nonsense. So I think, I agree with you entirely. We've also had some employer clients who've said, what about an AI tracker? Could you use one of those? But I mean, my experience at the moment, and certainly, other commentary I've seen on AI trackers is, unfortunately, they're actually quite unreliable. And also they might cause the employer issues if they're putting confidential information or personal data into an AI tool that's publicly storing that information. So my personal view would be for employers to steer clear of those AI trackers at the moment.
So, Hannah, let me put you in the shoes of our fictional employer. If you've received that big long a 50-page grievance, we are now certain that it is an AI grievance. What were the first sort of steps they should be taking to respond to that type of grievance?
I mean, take a deep breath, first of all. That's a good start, isn't it?
Yeah.
um,
Make another cup of tea.
Yeah, exactly. Get a strong coffee, maybe. I think the first thing that I would want to be doing, rather than diving into any form of investigation, would be just trying to get a face to face meeting with the employee. I think if you can speak to them face to face right at the beginning, that's likely to be the best way that you're really going to get to understand what actually is the crux of their complaint in factual terms and how do they really want it to be resolved. I mean, really what you're looking to get to is, can you please just set out your complaint in your own words? That is really the basic level of information that we're trying to get from them. And I think you're going to find it much easier to decipher what their complaints really are if they're sat in a room with you, because otherwise, as we say, you're going to get into investigating a lengthy grievance that actually might not even reflect their true complaint. So I think really that is absolutely what I would be doing. I know we've had a few employers say, oh, well, can we ask them if it was done by AI? Can we actually just ask that question? Well, yes, I don't think there's anything in principle that stops you from doing that. I certainly think at the meeting you can press the employee and get them to confirm whether the complaints are actually their own recollection of events and they represent their personal views, because essentially that is what a grievance is there to investigate, isn't it? Their own personal complaints. And we need to know really what the facts are to be able to investigate them properly.
Mm.
What
Yeah.
I'd want to be doing at that meeting ultimately is trying to come up with a key list of complaints that are manageable and that both parties understand, because otherwise, how can you properly investigate? I mean, I totally appreciate that employees might be reluctant to do that if they haven't come up with the grievance themselves.
Yeah.
We can talk in a moment, can't we, about some ways you might want to tackle that. But really, that would be my first port of call. I think there's probably some things an employer can do in advance of that meeting as well to help them, because really what you ideally want to go to that meeting with is some sense of what really the main themes of their complaint are. And so you could certainly still look at the grievance that they've sent, because you might identify, okay, really the theme of this is, let's just say they're working too many hours. Or the theme of this is they're being bullied by a colleague. And then you can use that to put to them and try and run through that at the meeting to keep a focus really on, okay, what are your specific complaints about your working hours or about that, allegation of bullying, to really focus that for the employee.
Yeah. And I think you said earlier that actually, the standard which we're concerned about is reasonableness. That you need to follow the ECAS code on disciplinary grievance procedures indicates that one has to follow a reasonable process, and therefore actually faced with a huge grievance, actually seeking to summarize the core issues. Yeah, I can't be, to my view, cannot be seen as anything other than sort of a reasonable approach. Um, what about the employer that is tempted to fight fire with fire and input the grievance they've received themselves into AI and get AI to summarize it? Is that something that you'd recommend? What are the issues that employer
I
needs to consider there?
Yeah, I think employers probably will be tempted to do that sometimes if there's like a 50-page grievance. I mean, again, firstly, I think you've absolutely got to consider whether there's any confidentiality or data protection issues of doing that. Because if you're not using an AI tool which you're fully satisfied protects your data and your confidential information, then I definitely would not be running it through that AI tracker, because you're going to inadvertently create a different risk for the company that you absolutely don't want to. If they have got a tool that they're happy to use, then there's not necessarily a harm in doing that. But my real concern with that is if it is an incorrect AI hallucinated grievance that contains a lot of irrelevant content, even the summary you get might not be that valuable. So whilst you might want to do it just to see what it comes up with and to see if it might be able to help you, perhaps get to a summary of themes, I'd be reluctant personally to solely rely on that. I would be more inclined to, try and see if you could pick out some key themes and then discuss those with the employee, or at least, look with, a very critical eye over what you get from that AI tracker.
But what happens if the employee just refuses to meet? I mean, I can imagine a scene where if an employee has used AI to draft their detailed grievance, they think they're they're sitting on an amazingly powerful grievance, and an employer is then trying to sort of summarize that. An employee might be reluctant, refuse to engage, and just sort of say, no, look, everything I've said is included in my grievance. I stand by it. What should employers do then, do you think?
Yeah, I think that's going to happen quite a lot. I think we've seen that already quite a lot. So I think absolutely, if an employee perhaps is, got this idea from AI that they're sitting on a gold mine and that they want to put the employer to as much work as possible, they may well do that. I think there's a few things an employer can do. I think firstly, it's actually important to note that the ACAS code says that employees and employers should make every effort to attend a grievance meeting. And actually, an employee can have their compensation, even if they succeed with a claim, reduced by up to 25% for an unreasonable failure to follow the code. So one, I think it might be worth reminding an employee of that if they're being particularly difficult. But also, I think I would want to push the employees to why they can't attend, just also to bottom out from the employer if there's any additional things we need to think about. So, for example, reasonable adjustments if someone was disabled. But assuming we've bottomed that out and they're really just refusing and we've reminded them about the ACAS code and they're still not engaging, I think employers sometimes panic and then just crack on with investigating each and every point. I would personally advise against doing that, given the fact that the ACAS code does allow us to adopt a reasonable approach. I think that probably a better approach, in my view, would be to try and create your own summary as best you can of what you consider the key complaints to be. You can then try and agree that with them, certainly. If they refuse to agree that, in my view, as long as we're satisfied we've really looked at the complaint and we've tried to engage with the employee about it and we've given them every opportunity to agree that, in my view, I think I'm not sure a tribunal would say that that was an unreasonable approach to then
Agree.
focus on the summary, as opposed to going off, looking for hours and days at case law and legislation that might not even be correct. I mean, I don't know what your view on that is, Nick.
I agree. I think employers ought to have a bit of confidence in that, and I think actually it speaks to the point you said earlier about the importance of putting in that work to try and understand the grievance and clarify it, as opposed to sort of just yourself putting it into a large language model AI program and summarizing it. Because then actually, if you've put in that legwork to sort of try and get to the very specific issues, and you have a reasoned basis for that, and you indicate to the employee that you're going to investigate that going forward as their grievance, and the employee is then just refusing to engage in that sort of process, actually, I think a tribunal would have a lot of sympathy with an employer for that approach. I mean, in a broader sense, because, this is a problem I think employers are going to have to sort of get to grips with, and they will be facing increasingly going forward. In a broader sense, what are the practical steps do you think they can do? Is it worth the employers relooking at their grievance policies to sort of tackle this issue?
I think it absolutely is worth them having a look at their grievance policies. I think there's probably certain amendments that we can make that will help with navigating this. So certainly we'd want to make sure that it's clear to employees that you do have the right to summarise the key points of their grievance if it is excessively long or unclear. And also that really you want to make it clear in that policy that they need to cooperate with the process of agreeing those key points, just so that is crystal clear. You also may want to make sure that the grievance policy does explicitly state that they have to, try and attend that grievance meeting, and the ACAS code requires that of them. In terms of other things, I also think I'd probably want to warn employees that if they do use AI, they need to carefully check the contents of the grievance to ensure it's factually correct and fully represents their recollection of events, so that that focuses their mind. I think probably also a reminder that it's not a legal process and that the purpose is to resolve concerns through investigation. And I probably would even go as far to say that they wouldn't usually take into account or respond to references to case law or legislation referred to in the grievance unless it was felt it was necessary to determine the outcome of the complaint. Because I think that just makes it clear from the outset, doesn't it, to the employee about what the process is and what will and won't be taken into account.
And sort of sets there in black and white um, the fact that the employer won't be drawn into that temptation of trying to argue those points where actually it's not the correct forum to do so. I think also as well, in addition to sort of looking at their grievance policy and procedures, it's sensible for them to be looking as well at their sort of the data protection policies and picking up some of the data protection issues that we've indicated, because there are risks associated to employers with employees putting potentially confidential, even proprietary information into the open source large language models. We don't know as yet how that might manifests itself going forward, and that can create risk for the business, risk for employers, which they will want to tackle with employees, I suspect.
Yeah, absolutely. It may well be information that's stored on the AI tool, mightn't it? And we don't want them to be inadvertently sharing that confidential or sensitive information or data, do we? So I think I certainly would be reviewing data protection policies or an AI policy if you've already got that, and set out clear guidance on AI usage for employees, particularly in the cases of grievance, so that we're crystal clear with employees that they cannot be putting that information in shared AI platforms and what the consequence would be for them if they breached that. And you might even want to cross-reference that in the grievance policy if you're having particular issues with this type of grievance, and even implementing training for employers. So, HR teams, managers on tackling the AI grievances, and also that aspect in terms of confidentiality and data as well.
Correct. Any other nuggets as a final sort of thought for employers?
Yeah, I think my final thought would be, obviously the best solution to all of this is that prevention is better than cure. So whilst we're never going to stop this completely, ideally reducing the number of grievances completely is the best strategy. And I think, again, as perhaps part of training or awareness that you're looking at within that organization, really you want to create a workplace where people just communicate openly and they raise issues informally at an early stage, so we perhaps don't get to a situation where an employee is feeling pretty disgruntled and then is more likely to lean on AI to raise a formal, complicated complaint. So I think the more we can push managers to, encourage people to resolve issues at an early stage and promptly, hopefully that means we are just less likely to see grievances full stop. I mean, I'm not naive enough to think that is going to resolve the issue completely, but I certainly think the more we can push that informal, open workplace culture, the better you're going to have chance of not getting into the situation of, really acrimonious grievances.
I think it's a really important point and one often overlooked, and I entirely agree with what you say. Well, look, that's great. Thank you, Hannah. That's been a really, really interesting conversation on the topic, and I'm sure will resonate with a lot of listeners. Thank you, everybody, for joining us today. Hopefully, you have found that interesting. If you would like more content, do let us know. please sign up to our news flashes, which can be accessed via our website. Follow us on social media platforms, in particular LinkedIn, for the content. And thank you for your time.